ஐயோ நான் வந்து லைட் போயிட்டு இருக்கோம். இல்ல இல்ல இந்த சைடு தான் போயிட்டு இருக்கு. சரி யாரு யூடியூப்ல ரீல்ஸ் பாத்தீங்களா? அது இல்ல
A very good morning to all of you. Hope you all are fine. खाना खाई कि नहीं? Very good. वो भी नहीं సాப்பிட்டீங்களா? తిన్నావా? ఎవరు? You come down. We'll give you food, no problem. Yeah, tomorrow we have the time to visit jail. Finally, we got the permission from the jail authority, jail superintendent, and certain he applied, he suggested us to follow certain conditions. Please listen to me one second. Macha, okay. Silence, please. So that means we are going to segregate because at a time it is not possible on our part to send you all of you at a time. So we are going to segregate, and the details informations we will send you to your WhatsApp group. Which time you will be allotted? In which group? We are going to segregate that group. Okay. So accordingly, you will visit the court. Not before that, not after that. Not before that, not after that. Because it's a very, if will create any problem, the next student, next phase students, they will suffer. They are not ready. Now it is very tough time. They are not ready to give permission. We wait there by the special request by the honorable director, sir. They finally gave permission from the police station and here also from the jail. Still, we have not get any confirmation from the court authority. Permission. We are waiting for that. Then only we will take you to the court premises for court visit. So before that, that's why today my esteemed colleague, Professor Abhijit sir, he will explain you details what you have to there once you will visit to the jail. To the jail, once you will enter to the jail, what you will observe, how you will, what you will do there, that our Abhijit sir will later on inform you. Okay. So with this, let us start our today's business, today's class. Let us hear all the lectures, and also we are going to arrange a special lecture program for different professors. We are going to invite them for your benefit. So with this, let me stop here for today. I would like to invite our esteemed colleagues, Professor Danya ma'am, to start the class. Danya ma'am.
Then it won't be. Then it won't go audible at the back, sir. No, sir. It won't be audible at the back if you reduce the volume. Good morning to all. Nice. Thank you, sir, for the warm welcome. And shall we begin? Okay, okay. No, sir. Okay. Okay, what will we be discussing is it's my mobile. Sir? No, sir, no, sir. Yes, sir. So what were we discussing yesterday? So what is the form of written statement? Could anyone explain? Make it fast. Yes, Gausia. Okay, that is it. But what is the format or the outline of a written statement? How you should begin with? First is the name of the court. Next, the case number. Then, parties, descriptions and the name of the parties. Then, huh? You'll jump directly to the relief. Rule, under which rule you are filing the statement, that is written statement submitted by the defendant or the counsel on behalf of the defendants under section, under rule 8, order 8, rule 1 of CPC. Then you begin, then what you have to begin with? How do you start the written statement? Full denial of the plaint. The suit is not maintainable either in law or in facts. The plaint is filed on so and so. The plaintiff has filed the suit for whatever it is, and he has filed the said plaint by suppressing all the material facts and misleading, and the purpose of misleading the court, or he has come with without clean hands, and then you have to write. What is the next sentence you have to write? What was it? I told you, na, you should by heart this and these few sentences. The defendant denies the contentions or the averments raised by the plaintiff, and it has been specifically denied unless and until it has been admitted. It will be it all has been denied. Whatever, if it is not admitted, all the other facts has been denied by the plaintiff or by the defendant. And you go into your sets of facts, then there is no prayer, as only one prayer is there, that the suit has to be dismissed. Okay, and you end by your verification and everything. Now there is a scenario where you have a counter claim. You have your own sets of facts that as if it is eligible to be filed as a plaint also. So you can file along with the written statement your contentions, your averments against the plaintiff in the form of a counter claim. That is under Rule 6A of Order 8 CPC. Is it clear? I'll give you an example how you want to draft the written statement with counter claim. The same set of cause title, everything will be the same, but the rule we have to add in addition, that is written statement, most respectful written statement along with counter claim submitted by the defendant as per Order 8 Rule 1 read with Rule 6A of Order 8 CPC. This sentence has to be there. Then also the same set, they rule madri po. Then you have to you will raise your set of facts and cases, right? That you have to raise in such a way that you draft a plaint. Nama plaint eppadi nama formulation pannirkomo. In that format, you have to draft your written statement as if a plaint. Got it? And when you add a counter claim in your written statement, what all things it has to be there. First thing is the body of contents or whatever it is, all the sets of facts. Next, if there is any schedule, all the details about the schedule. Then the valuation for the suit, and that your counterclaim should not exceed the pecuniary jurisdiction of the court in which the plaint is being filed. It is mandatory. If it is beyond the pecuniary jurisdiction, you have to file a separate suit in the court concerned, not along with this suit. So what all things you have to see? The pecuniary jurisdiction has to be within the limits which the plaint has been filed. Then valuation has to be there, and prayer, and also verification, and if there is any list of any documents that you want to produce, those documents and list of documents, if it is an attested copy, whatever it is, it has to be produced, and the certified copy has to be produced before the trial begins. So this is how a written statement along with a counterclaim has to be filed as a plaint. Yesterday, as one of the student asked, what if the plaintiff doesn't appear and the defendant is contesting, and what happens is he doesn't appear? His case would be disposed. His case would be dismissed, and the defendant hearing would be transposed. He will be transposed and will be termed as the plaintiff in the other case, in the new case. Once the plaintiff is dismissed, and the same way, if the defendant doesn't appear, and if he fails to submit a written statement within 30 days, which can be extended to 90 days, and also further extension under section 148 and then under section 151. Ivlo time period kadachittu, you are not filing the written statement, or if you fail to appear before the court on a specified date, the court can set you ex parte. a court can pass a decree of ex parte as if they have heard your contention and நீங்க உங்களை கேட்டு உங்களை that they have given you the right to be heard. They have you have your contentions has the court presumes that you have been heard and they will pass a judgment against you if the defendant doesn't appear. And whereas if the plaintiff doesn't, if he fails to appear for a continuous period of time, the court presumes that the court what the court would do, it would dismiss their suit. Now if there is a counter claim, the defendant therein would step into the shoes of a plaintiff and the court would pass a decree as if the original plaintiff is the defendant herein, and what happens, he would be set ex parte and ex parte decree would be passed against the original plaintiff. Got it? So this is how a plaint and written statement has to be drafted. So far is it clear? So what all things have we learned so far? First thing is a notice or format is clear than at the back. Is it clear? Next thing is the reply notice, then comes the plaint, and then comes the written statement. And all the written statement, and in the plaint also, it has to be accompanied by an affidavit. On the verification, I hope you understood the importance of verification. And the verification order statement, I will by heart up. All facts stated above are true to the best of my knowledge, belief, and information. And it has to be signed by one of the parties to the suit. It has to be verified, and the affidavit that they submit has to be verified by the advocate, solemnly affirmed and signed by the deponent at my office, who is personally known to me on dash day of dash month of dash year, and it has to be signed by the advocate also at the end of the affidavit. What is the importance of that affidavit? Because he is solemnly swearing before the court that it is he who is actually admitting the facts, that as per his knowledge and as per his belief, all the facts stated above are true. So this has been solemnly affirmed by the party to the suit, and that has to be verified by the counsel. And that and the dialogue you have to learn it by heart. Solemnly affirmed and signed by the deponent, who is personally known to me at my office at the place on dash day of dash month of dash year. Got it? And this has to be done by the advocate. And this is how you present the plaint, as well as this is how you give the written statement for a case. Now, if you are filing a case, along with the case, you want a relief, which is an injunction or which is an attachment. Or say, for example, this is a money suit, as we discussed in the notice. Notice we discussed a hypothetical situation where he owes him 1,65,000, and in security he gave him a check, and it was dishonored due to insufficient of fund. So those were the facts. Remember? Yes or no? So, what is the relief that the plaintiff wants? That either he has to get the money or anything equivalent to it. So what are things as an advocate you can advise him? First thing is, you will ask him to file a suit for realization of money. So on a realization of money, since it is a money suit, since it's a civil suit, it is like procedure now, or like even for filing written statement, even law is itself giving 30 days, which may extend to 90 days. 151 enlargement of time is there. Then also as for 148 you have enlargement of time. So it is a huge process. Or step by step, or money suit realize pananona, it at least to around minimum of 3 years right? Minimum of 3 years So immediate you need some kind of relief. Or there are situations wherein, what if the defendant absconds the city? Or what if he alienates all the property? Property how can you realize? How can you realize the amount? So you need some kind of immediate relief against the defendant. So as an advocate, you can give them the advice of filing any kind of interlocutory applications. So mostly in case of attachment, mostly in case of, for example, in a money suit, what you can do? You can ask for an interim relief. Interim relief in a way that either ask the court to pass a direction or pass an order asking the defendant to deposit the said amount within the court. Courtல deposit பண்றதுக்கு DD-ஆ submit பண்ணணும். If it is for 1,65,000, ask the court to pass a direction or order stating that the defendant has to submit the said amount, the said principal amount as security in the court. Or what is the second relief you can ask to the court? In the principal amount and with interest equivalent அவனுக்கு ஒரு property இருந்ததுன்னா you can ask the court for a injunction, card the court for an attachment. You can attach his property and from so உங்களுக்கு ஒரு security இருக்கு even if he tries to abscond the limits of this jurisdiction, or even if he tries to defeat the provisions of law, or in order to delay the case of the plaintiff. நான் என்னோட ப்ராப்பர்ட்டி என்னோட அண்ணா பேருக்கு I transfer. I made a fake deed or something, or adjustment settlement deed with my brother or something, and I transfer my property to my brother. So there are chances for alienation and I will not be able to get the relief which I wanted. Right. So what all reliefs you can get along with the plaint, you can file the attachment petition as well. So it will be heard in the first admission itself. The court may or may not pass the may or may not allow the attachment petition at the first instance. Or else what the court could do, it will send a notice, urgent notice அனுப்புவாங்க. Urgent notice may be within a week or so, though the other person could get, and they would appear and they can contest. So that is the discretion of the court, and that is where the advocacy skill has varradhu, because that is when you have to convince the court that the defendant is trying to alienate the property, or he is purposefully wanted to delay the provision, delay the case of the plaintiff. He would do such an act. Or especially in case of attachment, you have to include a paragraph wherein you have got information from so and so person, ஏதாவது ஒரு person பேரு வச்சிட்டு from so and so person, that this person, that the defendant is making arrangements or he is doing some kind of arrangements for alienating the property. Because I have sent the notice, so he has an apprehension that they might institute an attachment petition against my property. So in order to avoid that, he is trying to alienate the property. So this attachment has to be allowed, or it has irreparable loss or injury to the plaintiff. So that is how you have to formulate or draft a interlocutory application. So you should be aware of what all types of reliefs that can be given to the plaintiff. Idea irukkum. When a person comes to you with a grievances or anything, since only if you are aware of the law, உங்களுக்கு இந்த law பத்தி கொஞ்சமாவது knowledge இருந்தா மட்டும்தான் உங்களுக்கு தைரியமா உங்களுக்கு solution கொடுக்க முடியும். That is why we are asking you to please pay attention in classes. So okay, so shall we draft an interlocutory application? There are n number of interlocutory applications. For one example, the attachment. Another type of interlocutory application is what? Injunction is there, that you want to restrain the person from using such a pathway or whatever it, and you want to maintain your status quo. You wanted to maintain your status as a landlord, owner of the land, or you want that a person not to infringe into my property or trespass into my property. And for example, another type of interlocutory application is commission application. What do you mean by commission application? Who's in a commissioner who's appointed by the court? See, for example, there is a dispute with regard to a wall or something. Boundary dispute is there. Each and every time, the court personally cannot go and visit the site. So he cannot He cannot visit the site or go directly because n number of cases are coming up every day. So now, and there are yes, yes. Now there are circumstances where we will discuss whether circumstances you can apply for a commission application. First thing is, for example, if you don't analyze or if you don't இப்ப நமக்கு ஒரு வழி தர மதில் boundary dispute தான் இருக்கு அவங்க மதில் கெட்டிக்கிட்டே இருக்காங்க and it is coming inside your boundary as well. If you don't stop right now, இப்ப நீங்க கேஸ் கம்ப்ளைண்ட் பண்ணதுக்கு complaint file பண்ணதுக்கு அப்புறம் then they have to file a reply notice. By then they would build the complete the construction of the building. So an urgent commissioner would be appointed. He would visit the site, and in the commission application, you have to lay down some directions that has to be followed by the commissioner. What all that he has to inspect. First thing, he has to inspect the lie and location of the property. East, west, north, south, all the boundaries of the property, that is locating the property. Then come to what is the actual dispute with regard to the property. Is it infringement? Illa pathway irukka, illa appadi oru path irukka, illa appadi oru building irukka, what all whatever the commissioner sees, the commissioner has to write down and submit a report called the commissioner report, and he has to submit a mahasar. Mahasar na anga poi neenga ninnu prepare பண்ற details. That is how starting from the time you start your travel from your court premises, the time you like visited the plain schedule property, what was the actual dispute there. Then you can also ask questions to the, actually what happens is you are representing court, you have the authority to do so, and you can ask questions. All those each and every minute details has to be mentioned in the commission report. There is also one type of report called survey report. Survey report na land disputes the same, the survey stone there will be also a survey with you, and the surveyor will give you his report, and along with this report you have to file a commission application. So in commission application, advocates would give you a list of things that has to be inspected. All those things has to be mentioned in the commission application. So these are different types of commission. Under which section of CPC deals with interlocutory application? Section. Yes. This section deals with all these supplementary proceedings. Yes? That is order. Order 38 is with regard to what? Order 38 with regard to what? 39 is what? Then order 40. Order 26. Just go home and read section 94 of CPC. Okay, section 94 of CPC says about all the supplementary proceedings like which all? Order 38 rule 1. What is order 38 rule 1? Arrest before judgment. Then order 38 rule 5. Attachment before judgment. Order 39 injunction. Order 40 appointment of receiver. Order 26 appointment of commissioner. So please if you wanted to continue your profession as an advocate, in the provisions by heart got it. And while okay, while drafting an attachment, so no plaints today, even the what by filing counterclaim also, the defendant also can file all these interlocutory applications, and the plaintiff also can file. For example, if I wanted to file an interlocutory application, the petition it should be, the petition would be like, before the honorable so and so, and the case number, the parties. Now the parties would, like if the plaintiff is filing a petition, he is filing a petition, right, in the locatory petition. So his character would change as petitioner, plaintiff bar petitioner. If it is the defendant who is filing the application, he would be like defendant bar petitioner. And the other party would be respondent, becomes a respondent, defendant bar respondent or the plaintiff bar respondent, depending upon the circumstances. You understood? And that, and your details has to be given. Then the rule under which you are filing. Petition most respectfully submitted by the petitioner under Order 38 Rule 5. Order 38 Rule 5 is attachment. Attachment when you file a interlocutory application with regard to attachment, you can only, in as per section Order 38 Rule 5, you can only ask for a conditional attachment. Very important. Attachment na koi property attach panna directly kekka mudiyadu court. You can only ask for a conditional attachment. What do you mean by conditional attachment? Either ask the petitioner, ask the respondent to submit, to deposit the security amount. If he fails to do so within the stipulated period, pass an attachment order against the property of the respondent. So you, in order to claim for a attachment petition, you need to know under what all circumstances you can ask for attachment. Okay, first there is an apprehension that he might he might abscond the jurisdiction of the court. He might go outside India. He might purposefully to delay the execution of the decree which would be passed against me. If there are chances for the case to be decreed in my favor, and in order to delay that execution, he would abscond. He is trying to abscond the limits of jurisdiction. So once he abscond the limits of jurisdiction, we will not be able to realize money out of him. So those, and these are the provisions. If the court is satisfied that all these provisions is been satisfied, then the court will pass, either ask him to submit the security amount or pass a conditional attachment. And also in attachment cases, you need to prove that he is trying to alienate the property. You need to convince the court. Whereas in the case of injunction, what you have to prove is the balance of convenience and everything is in my favor. Prima facie case is in my favor, and an injunction, it has to be there. If injunction is not being granted, irreparable loss and injury will be suffered by the petitioner. So these are the facts that has to be included in an interlocutory application. Is it clear? Yes or no? Can you draft a plaint as well as a written statement? Up to your imagination, you can add your counterclaim set of whatever it is. With regard to the fact I gave for the notice. For the notice I gave, there are two parties. One has borrowed 1,60,000, whatever amount, that is up to your convenience. As per what promissory note I check, it's up to your imagination. And please draft a plaint and a written statement. அதுக்கு தகுந்த மாதிரி interlocutory application file பண்ண முடிஞ்சதுன்னா அது உங்களோட, I'm leaving it to your imagination, you can draft or உங்களுக்கு is the drafting portion is clear, right? So please draft a plaint as well as a written statement with regard to that problem I gave you for the notice. Clear? So that's it for today. Hope you enjoy the class. Sir. Sir, 3-1. 3-1.
ഞാൻ കുറച്ച് കാര്യങ്ങൾ ഇപ്പൊ പിള്ളേരോട് പറയും, തമിഴിൽ തർജ്ജമ ചെയ്യും, അല്ലെങ്കിൽ നീ പറയാ, നീ തന്നെ തർജ്ജമ ചെയ്യും. അങ്ങനെ വെച്ചാൽ ഞാൻ പറയട്ടെ.
അത് ആവശ്യമുണ്ട്.
അപ്പൊ ഇത് അവൻ നേരത്തെ മനസ്സിലാക്കി. Good morning. Good morning, students. Please listen very carefully. It's regarding subject visit that we are going to conduct tomorrow. Subject visit. Tomorrow we will go for a subject visit. Okay. So everyone has to, irrespective of boys, irrespective of your batch. Balaji, someone posts. Irrespective of your batch, everyone has to come to college by sharp 9:30. Okay, sharp 9:30 you have to be here. You need to give your biometrics, enter your biometrics by 9:30. As I told you yesterday.